The Department of Justice just filed an emergency motion that legal experts are calling the most urgent judicial intervention in executive branch conduct since the Watergate era. At 6:23 p.m. on February 13th, federal prosecutors submitted a 47-page emergency application to the D.C. Circuit Court requesting immediate injunctive relief to prevent what the motion describes as ongoing obstruction of a federal criminal investigation. And this is not a routine enforcement action or standard prosecutorial request for court intervention. This represents the Justice Department formally asking a federal court to restrain actions by the executive branch itself, with the motion explicitly stating that without immediate judicial intervention, critical evidence will be destroyed and witnesses will be intimidated within the next 24 hours. When career federal prosecutors file emergency motions requiring a hearing within 12 hours, citing imminent destruction of evidence by government officials, you know something catastrophic is unfolding at the highest levels of government. Hit that subscribe button right now because you won't want to miss any of the videos I release. The emergency motion, which was publicly docketed within minutes of filing due to the expedited nature of the request, contains allegations that multiple current sources describe as the most serious accusations ever leveled by the Justice Department against White House officials in a formal court filing. According to the motion, prosecutors have obtained evidence through cooperating witnesses that executive branch personnel have been directed to purge electronic communications, delete calendar entries, and remove documents from official files related to matters under federal investigation. The filing states that these actions are not isolated incidents, but represent a coordinated effort to eliminate evidence of potential criminal conduct before investigators can obtain it through legal process. This is not based on speculation or media reports. This comes directly from a sworn declaration filed by a senior FBI official accompanying the emergency motion, stating that multiple witnesses with direct knowledge have provided consistent accounts of systematic evidence destruction occurring within the White House complex. So what specific evidence prompted prosecutors to seek such extraordinary emergency relief? The motion reveals that the Justice Department has been conducting a criminal investigation into potential obstruction of justice, witness tampering, and misuse of classified information for the past 8 months. Sources familiar with the investigation say that prosecutors were proceeding methodically, gathering documentary evidence and witness testimony when they received information on February 11th from multiple cooperating witnesses that senior White House officials had ordered staff to begin destroying materials that could be responsive to grand jury subpoenas. The witnesses, whose identities are protected in the filing but who are described as current executive branch employees with security clearances, reported being instructed to delete emails, remove files from shared network drives, and ensure that no documentary evidence remained of certain meetings and communications from December and January. Smash that like button if this is making sense so far. The timing of the emergency motion is directly connected to the White House counsel resignation that occurred earlier the same day. According to sources familiar with the Justice Department investigation, prosecutors had been coordinating with the White House counsel's office to ensure preservation of relevant documents under established protocols governing federal investigations of executive branch conduct. When the counsel resigned, citing constitutional concerns, that coordination immediately ceased, and prosecutors lost their primary point of contact for ensuring evidence preservation. Within hours of the resignation becoming public, cooperating witnesses began reporting to investigators that they had received instructions to begin purging electronic records. That sequence of events convinced prosecutors that without immediate court intervention, critical evidence would be irretrievably lost before standard legal processes could secure its preservation. Here's where it really gets serious. The emergency motion asks the court to issue a temporary restraining order prohibiting any executive branch personnel from destroying, altering, or concealing documents, communications, or other materials related to 14 specific categories of information identified in the filing. These categories include communications regarding federal law enforcement investigations, discussions of presidential pardons for individuals under investigation, contacts between White House officials and foreign government representatives, and directives concerning the handling of classified information. The motion further requests that the court order the immediate preservation of all electronic data on government servers, email systems, and mobile devices used by 23 named individuals, with forensic copies to be made by court-appointed experts to ensure no tampering occurs. The legal standard for granting emergency injunctive relief requires prosecutors to demonstrate irreparable harm that will occur without immediate court action, likelihood of success on the underlying legal claims, and that the public interest favors intervention. The Justice Department motion addresses each element with detailed factual allegations supported by witness declarations. On irreparable harm, prosecutors argue that evidence destruction cannot be remedied after the fact because once documents are deleted or destroyed, they cannot be recovered regardless of any subsequent court orders. On likelihood of success, the motion cites federal obstruction statutes and case law, establishing that destroying evidence related to federal investigations constitutes criminal conduct regardless of whether formal subpoenas have been issued. On public interest, prosecutors argue that allowing systematic evidence destruction by government officials would undermine the rule of law and create a precedent where those under investigation can eliminate evidence with impunity. Drop a comment right now if you saw this coming. I read every single one. The procedural posture of this emergency motion is highly unusual and reflects the extraordinary circumstances prosecutors believe they are facing. Typically, the Justice Department uses grand jury subpoenas to compel production of evidence, and if recipients fail to comply, prosecutors seek court orders enforcing the subpoenas. This motion bypasses that standard process and instead seeks immediate injunctive relief based on evidence that documents are being destroyed before subpoenas can even be issued. A former federal prosecutor who handled complex white-collar cases told reporters that this approach is reserved for situations where prosecutors have credible evidence that standard legal processes will be thwarted by deliberate destruction of evidence, and that he had only seen such motions filed 3 times in a 30-year career, each involving organized crime defendants destroying records to avoid prosecution. The historical parallel that legal experts immediately drew is to the White House tapes dispute during Watergate. In that case, prosecutors sought court orders requiring President Nixon to turn over tape recordings of Oval Office conversations, and Nixon's attorneys argued that executive privilege protected the recordings from disclosure. The Supreme Court ultimately ruled in United States v. Nixon that executive privilege does not shield evidence of criminal conduct from judicial process. However, that case involved a dispute over access to existing evidence, not allegations that evidence was being systematically destroyed to prevent its discovery. This current emergency motion presents an even more serious scenario because it alleges active, ongoing destruction of evidence by government officials specifically to obstruct a federal investigation. Now things get absolutely wild. Within 90 minutes of the emergency motion being filed, Chief Judge Sri Srinivasan of the D.C. Circuit Court issued an order scheduling an emergency hearing for 7 a.m. on February 14th, just over 12 hours after the motion was submitted. The order directs the government to immediately serve copies of the motion on all affected parties, requires respondents to file any opposition by 6 a.m., and states that the court will hear oral argument at 7 a.m. with a decision to be issued from the bench immediately following the hearing. Legal observers note that emergency hearings scheduled for 7 a.m. are exceptionally rare and signal that the court views the allegations as sufficiently serious to warrant immediate judicial attention regardless of the inconvenience to normal court schedules. The bombshell moment came when reporters obtained the witness declarations filed under seal with the emergency motion. According to sources who reviewed the declarations, 3 separate witnesses provided sworn statements describing a meeting that occurred in the White House on February 12th, where senior officials discussed the need to ensure that certain documents and communications could not be obtained by investigators. One witness declaration reportedly states that a senior advisor explicitly told staff to delete emails and text messages from personal devices that had been used for government business and to ensure that no records remained of specific meetings that occurred in late December and early January. Another declaration describes being instructed to remove documents from official files and to claim, if asked, that such documents never existed or had been lost through routine document management processes. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. The declarations include specific details that prosecutors argue demonstrate consciousness of guilt and intent to obstruct justice. One witness reportedly stated that during the February 12th meeting, officials discussed the fact that electronic communications are difficult to fully delete and that staff should physically destroy any hard copies of sensitive materials. Another witness described being told that if questioned by investigators, employees should state they do not recall specific conversations or meetings rather than provide information that could be used in a criminal case. These allegations, if proven, would constitute textbook obstruction of justice under federal law, which prohibits destroying documents or encouraging false statements to impede federal investigations. The response from the White House was immediate and combative. Within an hour of the emergency motion becoming public, the White House press office issued a statement calling the filing a political hit job by rogue prosecutors trying to undermine the presidency. The statement claimed that routine document management and records retention policies were being mischaracterized as evidence destruction, and that the Justice Department was weaponizing the legal system to attack political opponents. The statement made no specific denial of the factual allegations in the motion and did not address the sworn witness declarations describing instructions to delete communications and destroy documents. Legal experts noted that the defensive posture and lack of substantive response to the allegations suggested the White House had been caught off guard by the emergency filing and had not yet developed a coordinated legal strategy. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone regardless of political perspective. The emergency motion reveals that prosecutors have been investigating potential criminal conduct by White House officials for 8 months, gathering evidence through cooperating witnesses and documentary subpoenas without the investigation becoming public knowledge. That level of operational security indicates a serious, professionally conducted criminal investigation rather than a politically motivated fishing expedition. The fact that prosecutors felt compelled to file an emergency motion seeking immediate court intervention suggests they have credible evidence that evidence destruction is occurring right now, not theoretical concerns about what might happen in the future. The legal framework governing destruction of federal records is clear and unambiguous. The Presidential Records Act requires preservation of all documentary materials created or received by the President and White House staff in the course of conducting official business. Federal criminal statutes prohibit destroying documents with the intent to impede federal investigations, and those statutes apply to all government officials regardless of position or rank. When prosecutors can demonstrate through witness testimony and documentary evidence that officials deliberately destroyed records to prevent their use in criminal investigations, it establishes the elements of obstruction of justice: a pending or foreseeable proceeding, knowledge of that proceeding, and actions taken with corrupt intent to interfere with it. This is not the first time federal prosecutors have sought emergency court intervention to prevent evidence destruction, but it may be the most significant instance involving executive branch officials. In the Enron investigation, prosecutors obtained emergency orders freezing documents after learning that company officials were systematically shredding files related to accounting fraud. In various organized crime investigations, prosecutors have sought immediate seizure of records based on evidence that defendants were destroying financial documents. However, those cases involved private parties or lower-level government employees, not senior White House officials engaged in conduct that prosecutors allege threatens the integrity of federal investigations into executive branch conduct. Smash that like button because it genuinely helps this video reach more people. The emergency hearing scheduled for 7 a.m. on February 14th will require the White House to respond to the specific factual allegations in the motion and the supporting witness declarations. Under federal court rules, parties opposing emergency relief must file written responses and appear at the hearing prepared to address the evidence presented by the moving party. That means White House attorneys will need to either deny the factual allegations with contrary evidence, argue that the alleged conduct does not warrant emergency relief, or contend that executive privilege prevents the court from intervening in internal White House document management decisions. The legal challenges facing the White House in opposing this emergency motion are substantial. First, the witness declarations provide detailed, specific accounts of instructions to destroy evidence, and those declarations are sworn testimony subject to perjury penalties if false. Contradicting them would require the White House to produce witnesses willing to testify under oath that the alleged conversations never occurred or that the witnesses are lying. Second, the destruction of federal records is a crime regardless of whether it relates to pending investigations. So even if the White House argues that document deletion was routine, prosecutors can point to statutory requirements for preservation. Third, executive privilege does not protect evidence of criminal conduct, so claims that the court cannot intervene in internal White House processes will fail if the alleged conduct violates federal law. So let's break down what the court will likely consider at the emergency hearing and what outcomes are possible. The judge will first examine whether prosecutors have presented sufficient evidence to establish that irreparable harm will occur without immediate intervention. The witness declarations describing active, ongoing evidence destruction likely satisfy this requirement because, unlike many emergency motions based on theoretical future harm, this motion alleges that destruction is happening right now and will continue unless the court acts. The judge will then evaluate whether prosecutors have demonstrated a likelihood of success on their underlying claims that the conduct violates federal obstruction statutes. The detailed factual allegations and legal citations in the motion present a strong case that intentional destruction of documents related to federal investigations constitutes obstruction, regardless of whether formal subpoenas have been issued. The most likely outcome is that the court will grant at least a temporary restraining order preserving documents and electronic data while allowing both sides to brief the issues more fully for a preliminary injunction hearing. Such an order would prohibit any further destruction of materials identified in the motion, require preservation of electronic data through forensic imaging of relevant systems, and potentially appoint a special master to oversee compliance. The order would remain in effect for a limited period, typically 14 days, during which prosecutors would need to seek a preliminary injunction through more extensive briefing and evidence presentation. A former federal magistrate judge told reporters that given the seriousness of the allegations and the risk of irreparable harm, any judge would likely grant some form of emergency relief to maintain the status quo while the legal issues are resolved. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. The implications of this emergency motion extend far beyond the immediate question of preserving documents. The Justice Department has essentially declared in a public court filing that it is conducting a criminal investigation of White House officials for obstruction of justice and related offenses. The investigation has been underway for 8 months, involves multiple cooperating witnesses, and has now reached the point where prosecutors believe evidence is being actively destroyed to thwart their efforts. This is not a counterintelligence matter or a civil enforcement action. This is a criminal investigation that could result in indictments of senior government officials if the evidence supports charges. The political ramifications are immediate and profound. Members of Congress are demanding briefings on the scope of the Justice Department investigation and the evidence supporting the emergency motion. Republican senators who have defended the administration through previous controversies now face questions about whether they can continue that support when federal prosecutors are alleging in court filings that White House officials are systematically destroying evidence. Democratic committee chairs are preparing to issue subpoenas for documents related to the investigation and are coordinating with Justice Department officials to ensure congressional oversight does not interfere with criminal proceedings. The emergency motion has transformed what was a largely secret criminal investigation into a public constitutional crisis about whether executive branch officials are above the law. But beyond the immediate political and legal implications, this emergency motion represents a fundamental test of whether the justice system can hold powerful government officials accountable when they attempt to obstruct investigations into their own conduct. The framers understood that those in power would be tempted to use their authority to shield themselves from accountability, which is why they created separation of powers and an independent judiciary. When federal prosecutors present evidence to a court that executive branch officials are destroying records to impede criminal investigations, it triggers the system of checks and balances that prevents any single branch from placing itself above the law. The court's response to this emergency motion will determine whether those constitutional protections remain effective or whether executive branch officials can thwart investigations through evidence destruction with impunity. Stay with me. What comes next will completely change how you view the situation. The emergency hearing scheduled for 7 a.m. will be open to the public and broadcast live due to the extraordinary public interest in the proceedings. Legal observers expect the courtroom to be packed with reporters, congressional staffers, and members of the public trying to understand the scope of the allegations and the evidence supporting them. The hearing will provide the first opportunity for White House attorneys to respond to the specific factual allegations in the motion, and their response will reveal whether they intend to contest the facts, challenge the legal authority for the relief sought, or argue that executive privilege prevents judicial intervention. This goes far beyond a routine evidence preservation dispute. It represents the Justice Department formally accusing White House officials of engaging in criminal obstruction by systematically destroying evidence related to federal investigations. The allegations are supported by sworn declarations from multiple witnesses describing specific instructions to delete communications and destroy documents. And the requested relief would place White House document management under court supervision to prevent further destruction while prosecutors pursue their investigation. If the court grants the emergency motion, it will mark the first time in modern history that a federal judge has issued orders restricting White House officials' ability to manage their own records based on evidence of criminal evidence destruction. If this blows your mind, hit that like button right now. Here's the situation as it stands right now. The Department of Justice filed an emergency motion at 6:23 p.m. on February 13th, seeking immediate court intervention to prevent ongoing destruction of evidence by White House officials. The motion is supported by witness declarations describing instructions to delete communications and destroy documents related to federal investigations. Chief Judge Srinivasan scheduled an emergency hearing for 7 a.m. on February 14th, requiring the White House to file opposition by 6 a.m. and appear prepared to address the allegations. Legal experts say the court will likely grant at least temporary relief to preserve evidence while both sides fully brief the legal and factual issues. When career federal prosecutors file emergency motions accusing White House officials of systematic evidence destruction, supported by sworn witness testimony describing specific instructions to delete records and obstruct investigations, we have entered genuinely unprecedented constitutional territory. The Justice Department has made clear through this filing that it is conducting a serious criminal investigation of executive branch conduct, that the investigation has produced substantial evidence, and that prosecutors believe White House officials are actively destroying that evidence to avoid accountability. The emergency hearing, less than 13 hours away, will determine whether the courts can effectively check executive branch attempts to obstruct investigations into official misconduct. Before we go any further, smash that subscribe button so you never miss content like this. Here's where things stand in the next 13 hours. White House attorneys must file their opposition to the emergency motion by 6 a.m., addressing the specific factual allegations and legal arguments presented by prosecutors. The emergency hearing begins at 7 a.m., with both sides presenting arguments about whether immediate court intervention is necessary to prevent irreparable harm. And the court will issue a decision from the bench immediately following the hearing, potentially imposing the first judicial restrictions on White House document management based on evidence of criminal obstruction in modern American history. Keep close watch on developments overnight and at the emergency hearing tomorrow morning. The White House legal response will reveal whether officials intend to deny the factual allegations or challenge the court's authority to intervene. Testimony at the hearing may include additional details about the evidence prosecutors have obtained and the specific conduct they are investigating, and the court's decision will establish whether federal judges can prevent executive branch officials from destroying evidence when prosecutors present credible allegations of ongoing obstruction. What happens in the next 13 hours could determine whether the rule of law applies equally to all government officials or whether those at the highest levels can thwart investigations by eliminating evidence. The emergency motion has been filed. The witness declarations have been submitted. The hearing is scheduled for 7 a.m. tomorrow. And the question of whether White House officials can systematically destroy evidence to obstruct federal investigations is about to receive a definitive answer from a federal court. The stakes have never been higher. The allegations have never been more serious. and the emergency judicial intervention that could preserve critical evidence or allow its destruction is less than 13 hours away. Pause for a second and hit that like button if you're finding value in this coverage. The evidence is being destroyed right now. The prosecutors have asked the court to intervene immediately, and the hearing that will determine whether the justice system can stop executive branch obstruction begins at 7 a.m. tomorrow morning.